Is it time to update your will? On this episode of Millstone River Live, 10 reasons you might consider updating your will. Welcome to Millstone River Live, a podcast brought to you by Millstone River Wealth Management. Adam, how we doing?
I'm doing all right. So maybe before we tackle some reasons why it's helpful to dust off the will and decide if changes need to be made, let's start with what is a will.
Sure. I think that there is definitely some confusion about what a will is. More importantly, maybe what does it do? So we'll hear it called a last will and testament. It's just a legal way of saying how are we going to express our wishes about distributing our property, our assets after we are gone. Who should be managing that? Who should inherit our stuff? Who should be responsible for carrying out our wishes? We call that person an executor. The will allows individuals control over how their assets are distributed after they have passed, and it can help avoid disputes among family members. Ever hear of a family fighting over their deceased family members' belongings?
Never.
It is important that we should say at this moment that consulting legal professionals when creating a will or reviewing a will ensure that it complies with all relevant laws, regulations, and is done properly to carry out exactly what you are trying to do. So, Adam, we're going to talk about 10 reasons today. We should say these are in no particular order of priority or otherwise. Why don't you give us the first one on the list?
A very common one is the birth of a first child. And Laura and I have just done this ourselves as we started a family and then had our two girls. The focus is generally on who a choice of a guardian might be for your child. If you're establishing trust within the will, it will also be an opportunity for you to communicate who the trustee should be. The will should be flexible enough to accommodate the possible birth of future children. And ideally, this is some planning that you're going to do before your child is born. So, change in family dynamics is obviously a reason. Matt, what's another reason why change in family dynamics might make you rethink your will?
Yeah, so having that first child or maybe second or third is certainly a whirlwind, a lot of activity, a lot of things going on, and your will could easily get lost in the shuffle. But here's another one. If you're thinking about divorce, this is not nearly as fun as having your first child, right?
No.
But the timing is important if you're considering a divorce from your spouse. And if you're going to update your will, the time to do it is probably right away, before filing for that divorce. Remember, if your spouse has marital rights to a portion of your estate if you die before you've completed that divorce proceeding, that may not be the outcome you wanted, or for other members of the family or other heirs. So once you file that divorce, it's usually difficult to make changes to the will until after that divorce is finalized. So executing that will before you commence the divorce means your spouse will not receive all of the money if you die before the divorce is complete. It might sound like a horrible thing to think about, but being a little bit strategic on your wishes could pay dividends later.
Once you've gotten divorced is also a reason to provide some updates. Generally, once you're divorced, your spouse will no longer have the same rights to the estate as they did before. But it's still important for you to decide if not your ex-spouse who's getting the funds, well, then who? So it's important that you update your will as soon as permissible so your new beneficiaries are clearly identified. And also, as an additional factor you may want to consider, any investment accounts in which you have a listed beneficiary, it's also important that you change those as well so that it communicates your wishes. Matt and I have gone through experiences where that is neglected, and it can be a real mess, whereas a simple form would have clearly made sure it was in line with your legal documents.
So you just mentioned having your first child. Now I'm going to fast forward the clock quite a number of years and say, what happens when that child gets married? Probably those years from birth until their own marriage will fly by, and it's easy to lose track of that time. But the issues that you addressed in that earlier will may not still be applicable when your baby is a spouse themselves, especially if they later get divorced from their spouse. So you may be able to mitigate some of the lack of a prenuptial agreement that they may have created a problem by creating a trust in your will or including a postnuptial requirement before your child can receive any distributions from your estate. Might sound awful to think about, but how many times could a problem have been prevented by doing a little bit of this legal planning before the problem became a problem? So creating the will after your child gets married or updating your will after they get married will make sure, first, that those problems from that marriage don't occur. And if you do happen to die before the marriage, anything you leave your child would not be considered marital assets in most states around the country. And again, I emphasize, as we always do, consult your attorney and make sure you're doing it right for your circumstances and the state that you reside.
Another not so fun to think about is, what happens if one of your beneficiaries runs into some trouble or hardship? We've gone through situations where unfortunately a beneficiary creates a substance abuse problem, or maybe they're a business owner that has litigation that's attached to them. That creates a necessity for you to review how your assets are left and to potentially make changes so that you can ensure that the distribution of your funds, goes under the current conditions.
Yeah, and then on top of that, as long as we're dishing out maybe some bad news, what happens if one of your executors or beneficiaries were to die before you? So if your estate plan and your will names an individual to either manage the estate or receive any funds or assets, and that person is no longer alive at the time of your own passing, that may be a good reason to update your will at that point. The old will may have named a contingency plan. It may leave undistributed funds to a deceased person's children, for example. But it's always smart, we think, to reevaluate that decision at that time based on who's around when that person has passed.
Change in family dynamics obviously has been a lot of the reasons as to why you might consider updating. But sometimes it's the government, Congress, that will force you to rethink. Anytime new legislation is passed, which, can be done by, it seems as though Congress does it every few years, it can derail your estate plan. State tax laws have changed, fairly recently, which include updates to how inherited IRAs, same-sex marriage, family business succession planning works. So it's make sure to ask your attorney every few years if there's any new laws that are relevant to your estate planning. I can give an example with a client recently. New Jersey made some changes, and just the change of the language of just a sentence or two actually had a pretty major effect on how the distribution inheritance of their assets would be followed through without the appropriate edits. What's a fun reason, Matt, that you might want to look into your will?
Well, I guess it could be fun or it could be sad, depending. But we're talking about you giving away your own money and your own belongings. What if you are the receiver of someone else's windfall, and that becomes a sum of money that you didn't have when you prepared your current will? We'd say that's probably a good time to check in with your attorney and make sure that the will you have is up to date, or if it needs a little modification at that point. It could be because someone left you their belongings on their passing. It could be a lottery winning. It could be some sort of inheritance from a relative that you didn't expect. But any of those would be a good reason to update the will, or at least make sure that your tax planning is in good order and that you're not leaving your heirs with some unforeseen, maybe negative consequences of that windfall.
taking some of that money from the windfall and buying property abroad takes us to our next reason. So whether you plan on moving to another country or just purchasing property there, many countries have treaties with the United States allowing for the mutuality of wills. But transferring property in one country may be delayed. The will must be probated in the other country. When we've had clients purchase property abroad, local legal representation generally says you may want to consider having a separate will for the country that you're purchasing property with. So I think that's 9. Matt, maybe you could take us to 10.
All right, sure. So we have one more reason for you, and that is what happens if your family or friends become enemies. The problem with animosity among family or friends in the will are compounded if one party in your family is unfriendly towards another. And only your nearest family members can easily fight your will, since your next of kin are required parties to probate. But while your friends have no default rights, we still think that it creates a problem for everybody who survives you. If you think your family will try to contest your best friend's bequest in your will, consider adding a no contest clause, and that'll serve to disinherit the aggressive family member if he tries to attack your friend or the other relative. I've heard from multiple estate planning attorneys over the years, when there's a will, there's a relative, and sometimes that doesn't necessarily mean good things. So making sure that everybody stays friends, and if that changes, again, another reason to take a look and make sure that your will is current, it's the way you want it to be. And for all of those reasons, we think it's a good idea to update your will. We hope you've enjoyed this episode of Millstone River Live. Feel free to share it with someone you think might benefit. Millstone River Wealth Management is an independent wealth management firm based in New Jersey with offices in Manasquan and Marlton. We form a supportive partnership with our clients and help with financial education and planning. You can send feedback and questions to podcast at millstone-river.com. More information about our firm can be found online at millstone-river.com. Thanks for listening.